Good afternoon. Thanks for joining me today. I'm attorney Maana Hickson. I'm an elder law and estate planning attorney. My practice is Hickson Law Group. And today we're going to be talking about how to qualify for MassHealth benefits in a nursing home. I'm going to share my screen. Okay, first screen there is just a little bit of background on myself. With respect to my practice, my primary practice is assisting individuals with applying for long-term care benefits in the community as well as in nursing homes. So what is Medicaid? Medicaid is a federal and state welfare program that provides benefits to eligible individuals to cover the cost of long-term care. In Massachusetts, the Medicaid program is referred to as MassHealth. And so MassHealth covers the cost of long-term care. So when an individual is in a nursing home and they're looking to apply for Medicaid benefits, that benefit will help pay for the cost of that care. So how do you qualify for benefits in a long-term care facility? So there's an asset limit. As a single person, there's a $2,000 asset limit. When there's a married couple where one spouse requires care, the asset limit for the healthy spouse is $154,000, $154,140 for the healthy spouse, plus $2,000 for the spouse requiring care. In the situation where it's a married couple with both spouses requiring care, the asset limit is only $3,000. So you can see there's a significant difference in terms of the asset limit for a married couple where there's a healthy spouse as opposed to a married couple where both spouses require care. There's no income limit to qualify for the MassHealth program. However, some of the income may be required to be used to pay for the cost of the nursing facility. So what assets are countable? Assets that count towards the $2,000 asset limit. Any bank accounts, brokerage accounts, stocks, bonds, CDs, cash, vacation properties, some individual retirement accounts, 401ks and pensions, and the cash surrender value of life insurance where the total face value of the policy is more than $1,500. So as you can see, many of the assets owned by individuals are considered countable. However, there are assets that are non-countable. So these assets do not count towards the $2,000 asset limit. Generally, the principal residence is non-countable. Household and personal belongings is non-countable. One automobile is considered non-countable. Income producing rental property as well. So if there's a vacation rental home, that could be considered a non-countable asset. Assets that were transferred to certain irrevocable trusts more than 5 years ago may be considered non-countable. Life insurance with the total face value of less than $1,500, a $1,500 burial account, prepaid funeral or irrevocable burial trust plot maintenance programs, annuities satisfying state requirements, and some IRAs, 401ks, and pensions are also considered non-countable. So I'm going to touch now on some of those non-countable assets and get into a little bit more detail. So income-producing rental property. The way that it's defined is business and non-business property essential to self-support and property excluded under a SSA-approved plan for self-support are considered non-countable assets. So what does that mean? The income-producing rental property must generate 6% of its value annually. So how is that calculated? The net rent, which is the business profit, is based on gross rent, less mortgage, real estate taxes, homeowners insurance, condo fees, water and sewer, and there must be at least a few $100s net monthly. So if you meet that criteria, owning an income-producing rental property, that will be considered a non-countable asset. Pension plans of the community spouse. So a pension fund is a retirement plan established by an employer to provide benefit payments to employees upon retirement or disability. Pension funds that are being set aside by an individual's current employer are not countable as an asset. So a 401k set aside by a current employer is non-countable. Now, this is important because in the situation where there is one spouse in a nursing home and there's a spouse that's currently in the community working and has a current 401k being set aside by their employer, that asset is not considered a countable asset. So this could be a significant asset which is not attachable by the state. Irrevocable trusts. So assets that were transferred to specific irrevocable trusts over 5 years ago may not be countable. There are some requirements with these trusts, so not all irrevocable trusts provide this level of protection. The grantor, the person that's creating the trust, they can be the beneficiary of income from the trust. However, they cannot serve as trustee of the trust, and they cannot be the beneficiary of the principal of the trust. So many people get nervous with these types of arrangements in terms of giving up a certain level of control with respect to having access to that principal. However, if you feel comfortable giving up that control and you set up one of these types of trusts and transfer assets into these trusts, 5 years and a day after that transfer, those assets should be protected and not attachable by the state if there's a long-term care need. So, in terms of how the income of the institutionalized spouse is paid to the nursing home, a monthly portion of the income is paid to the nursing home. And the way that it's calculated is the gross income, essentially. So, Social Security generally, maybe a pension, minus a personal needs account. So, everybody's allowed to keep $72.80 a month from their income to provide for personal needs. So hair appointments, nail appointments, anything along those lines, that $72.80 can be used towards. Health insurance premiums are also deducted from income. And if there's a spouse living in the community, it's a possibility that they may be allowed to keep a portion of the income before the balance is owed to the nursing home. There's a calculation to determine what the community spousal allowance is, if any. Generally, there may be an allowance for those individuals where the community spouse lives in an assisted living facility, or if there's a mortgage on the property. So let's talk a little bit here about crisis planning strategies for the protection of assets when long-term care is needed. So this is the stage where one spouse or an individual is in the nursing home, they're out of rehab, and this is now going to be a long-term care stay. Some individuals have long-term care insurance. Long-term care insurance is insurance that covers the cost of long-term care. The way that it works is a certain benefit depending on what was originally purchased. It could be $300 a day. It could be less than that. There could, beyond the long-term care insurance, be a balance owed to the nursing home beyond the benefit provided. In this situation, there are certain long-term care insurance policies that protect a primary residence from MassHealth estate recovery. So if you have a long-term care insurance policy that provides for at least 2 years of coverage in a long-term care facility, and that policy has a deductible period of less than 365 days, it's possible that the primary residence will be protected. If there is a question about the long-term care insurance, I certainly recommend reaching out to either the long-term care specialist or an elder law attorney to determine whether or not that protection, that policy qualifies for that protection. Spend down. So assets can be spent on anything for the applicant. They can also be used to purchase an irrevocable funeral contract, a burial account with $1,500, or assets may be transferred to certain individuals without a penalty. Those individuals are a spouse. So there's no transfer penalty between spouses. A disabled child. So assets can be transferred to a disabled child or in a trust for a disabled child without triggering any type of penalty. Assets may also be transferred to a caretaker child. So a caretaker child is a child that's lived with the individual for at least 2 years prior to needing nursing home care and providing the level of care as if the individual was in a nursing home. So oftentimes children will move in with their parents and assist them for a certain period of time. And it's possible that if they do provide that level of care, a home may be transferred to the caretaker child without a penalty. The other transfer that wouldn't incur a penalty would be if you have a sibling with an equity interest in your property. So if you are living with a sibling and that sibling has owned an equity interest in the property for at least 1 year, the property can be transferred to that sibling without any penalty. There's also the option of an immediate annuity. In the situation of an annuity, the individual uses the excess assets, so assets that exceed the $2,000 asset limit, or in the case of a spouse, a healthy spouse in the community, assets that exceed the 154 roughly asset limit can be used to purchase a Medicaid qualified annuity. The way that this annuity works, and it's nothing that would be purchased in advance, it would only be purchased at the time of a long-term care need. The annuity pays a stream of income to the annuitant over their life expectancy. So for many individuals where there's a spouse living at home, that spouse will purchase an annuity and have that annuity payable to them over a period of time until they get all of the money back. MassHealth is only looking at the value of the assets as of the date that the assets go into the annuity. So once you have met the criteria of the asset limit, they no longer look to see the value of the assets in the community spouse's name. And the annuity has to include specific terms. It's not an investment tool. It's specifically for MassHealth purposes. Okay, so if you need to connect with us, our information, my information with respect to MassHealth or elder care needs, it will be in the chat, as well as it will be circulated in a video after the presentation. If there's any estate planning needs, Borchers Trust Law is available as well, and their information will be in the chat and available on through the video as well.